All rise. The Court of Appeals Division 1 is now in session.
Good morning. Please be seated. We are here for oral argument in cause number CV 230143, Growth versus Tenbar et al. These proceedings are being video and audio recorded as well as live streamed, so I'd ask you to please introduce yourself and your client at the beginning of your presentation. Each side will have 20 minutes in which to present their argument. You are responsible for reserving any portion of that time for rebuttal should you choose. We have read the briefs. We have discussed this case in conference at length this morning. We are familiar with the facts. Please take that into consideration during your presentation. And at this point, I would ask counsel if you're ready.
Good morning. May it please the Court. My name is Rob Royal. I'm appearing today on behalf of Growth Opportunities, Inc., whose representative T.J. Geary is in the courtroom today. In looking over the briefs in this case, a couple things became quite clear. Number one, this is a case about a commercial lease and a leasehold interest. It is not a case about a management agreement and the services performed on the property. The second thing that I think became quite clear when you look at all the briefing together is that there are numerous questions of fact, which I know is our principal argument that we make in our brief, but that's because there are. And a jury needs to determine a number of things that just jump out at you when you are reading these briefs, like the meaning of certain documents, the meaning of certain testimony from witnesses, settling conflicting information. For example, Bruce Camden worked for GMX, and Bruce Camden saw that there was an issue that he had to deal with respect to something from the city of Phoenix about an odor problem. And what they told him is, look, we need to figure out who the tenant is. And so he calls Mr. Barber, who is Tenbar's owner and representative, and says, I've got this issue with this lease. And Mr. Barber decides to send back a scratched out lease and says that's all you need. Now that's what testimony says, yet they're looking at other testimony. And the only way that document, that letter, that situation, and that testimony can be resolved is to have the jury look at it and make a decision about it.
Counsel, you started out saying this is about a commercial lease. There was some sort of contradictory back and forth about whether that is the sole issue that we're being asked to look at. Can you clarify that for me?
Well, it's not the sole issue because others are raised. For example, they say that we abandon our damages, and so we have to address that, and did so in our reply issue. We have a number of claims that have different elements, and so we have to examine whether summary judgment was appropriate because there's no fact dispute under each of those claims and each of those elements.
So, but if we address the lease issue, does that dispose of any of those other issues?
Well, I don't think so. For example, when you're taking a look at unjust enrichment when there is no contract, you got to look at, is there an enrichment and is there an impoverishment?
Well, no, we also have to start with whether or not there's a remedy at law, and if there's a lease, doesn't that take care of unjust enrichment?
Yes.
Okay,
and
so
promissory estoppel.
Okay.
Yeah, we pled in the alternative for the reason we knew they were attacking the lease, and they're trying to tell us that there was no lease. And so when they say there's no lease and we say there's a lease, there's that dispute. When you take a look at the creation of the lease, what do we have here? We start with a written lease that was entered into between Tenbar and the company AGM, whose principal is Mr. Farekis. Then AGM is purchased by GMX. And Mr. Farekis even contacts Mr. Barber to say, this has happened. So now we're sitting with a written lease, acknowledged by the landlord that there's an assignment pursuant to that AGM agreement.
That's not exactly what he said. What he said is we will need to get this moving. Isn't that correct? He didn't say we've assigned the lease.
That's part of what was said. But there's also another communication later on that came up, and there's also a letter leading up to the communication that Mr. Camden had with Mr. Barber.
So when Mr. Camden took over GMX,
No, he's just one of the persons that was
he's the
managing.
managing member,
Yes.
allegedly. So when he takes over that company, he was aware that an official assignment had not occurred, was he not?
I don't think there's evidence in the record for that.
Couldn't we imply there's evidence for that when we look at the fact that he called Tenbar, Bill, and said, I can't deal with the city because this lease is not in our name?
Yes, he recognized obviously that there was a lease. There had been performance under the lease. There's been rent exchanged.
And when we look at rent exchanged, when we have a management company, is it not typical for a management company to make rent payments on behalf of the clients it's managing? I mean, what do we infer from that?
Well, that's a contract they decided to enter into, and I don't think that's necessarily normal. I'm not saying it's not. However, in this case, we're looking at a lease, and there's a lease obligation on behalf of GMX to pay that rent. And Barber knew about GMX sitting on those premises. He performed services, maintenance service when requested, and then that's demonstrating the leasehold interest and the right for the person to be there. The management agreement is what goes on that property. And there was the company that owned the crop, and they wanted GMX to, they hired them to manage the growing of the crop. That's two different things. One's a lease and one is a management agreement.
And did Tenbar ever say that it was aware of the management agreement when it was taking the rent from GMX?
Yes, I think that's in the record a little bit later on.
From the very beginning, it always knew?
Well, I always knew because there was a written contract with AGM to begin with, and Mr. Farakis was the person communicating with Mr. Barber in 2013, 15, and 17, which are the key dates of the written
Right, but
documentation.
my point is, GMX started paying rent at some point,
Yes.
17. Did Tenbar have noticed that there had been a management agreement at that point? I didn't think it was clear that they had truly known of the management agreement.
Well,
Is it a fact issue?
it's probably a fact issue because I don't recall anything in the record that fully demonstrated that, probably leading to your question.
And then
We certainly
let me
can
ask
infer that.
this. Isn't it a fact issue as to whether Tenbar just assumed it was a management thing that was happening with the rent coming? That's not something that we can say as a matter of law, one way or the other.
No, you can't say that as a matter of law, and that's why we put into our briefing the evidence demonstrating the communications between Mr. Farakis and Mr. Barber on behalf of Tenbar with respect to the GMX.
Let's move on to something else that's, that is a fact challenge, I think, for your client, which is after this scratched-out lease is what I think is the best way to call it, is sent, and apparently they worked a little with the city of Phoenix, but still GMX followed up with we still need to get this formalized. Is that dispositive of the issue, or is that a fact issue that the jury needs to weigh all of this and figure out?
Well, it's a fact issue because the jury needs to weigh the evidence that is presented on Barber's behalf, Mr. Camden's behalf, the documentation leading up to that point, and determine whether or not Mr. Camden's testimony can be inferred to say, look, we know there's a lease, we're performing under the lease, we're doing what we're supposed to under the lease. This company that Mr. Farakis runs is the one that's asking us to grow the crops. They need a place to grow the crops. And this is all something that's a fact question for the jury to decide when they're examining that issue.
But when we look at contract law, so the initial parties to the lease, GMX is not there. You've got Tenbar. You've got Farakis, who's involved in this heavily at every level in every entity. But what you have is an August 7th letter of 2017, and where Camden says specifically, we are going to need to do these things to get this assignment. So he's acknowledging there has not been an assignment, and this is something that needs to happen in the future. How do we get around his acknowledgement that he was aware that GMX did not have the lease at that point?
There's evidence, as you suggest, from the record to that point. There's also evidence demonstrating that there was a lease, that GMX understood it to be leased, that they operated under the lease, they performed under the lease, and when the issue came up with the city a little bit later, that it had to be addressed because the city said, look, we see AGM on this lease. We don't see GMX on this lease. And so it's a call to Barber after 2 or 3 years of this, and Mr. Barber just simply says, this is all you need. And there's a real question of what the meaning of that is. We say that's all you need because now you know this confirms your lease that we've been operating under, and here it is in writing, and they have a different interpretation.
Is it not incumbent upon your client, GMX, to pursue the assignment? I mean, had they said, this company that you entered into the lease with, we've acquired all their assets, now we want this lease assigned to us. And if Tenbar had refused, you would have many defenses at law, but they never went through the step of asking for the assignment of the lease. So that's what's confusing to me. Help me understand.
Yeah, you bet. So initially, when the sale took place involving GMX and AGM, and within a month thereafter, GMX was starting to pay their rent, that's when that one conversation was held between Mr. Farekis, who was growing the crop, who was also at that time a member and manager in GMX, contacting Mr. Barber to advise him, hey, this is what happened. You know, we sold the company, you know, there's a provision in there that talks about the lease is also being assigned, and everybody was good. The best way absolutely would have to document it better, but they did not. So they performed. If there's not a lease, that's why there's the other claims that we brought. But also, as time went on and this issue with the city arose, it became something we needed in writing. So they just confirmed in writing that the lease was already in existence, and then the contract was truly formalized by the intent of the parties and a meeting of the minds that they had, at least by the time there was the scratch-out lease delivered.
And at what point would we start to look at waiver? I'm trying to understand, because it seems that at some point that it's the landlord who waives, not the tenant. The tenant can say, hey, we want this officially done, but the waiver can occur if the landlord doesn't pursue it.
I think the waiver starts at the time that communication is made after the sale of AGM to GMX with the communication. And so now we are starting a period of time in which there's knowledge on behalf of the landlord that, okay, we got a new tenant in there, it's pursuant to a written lease and an assignment, and now I'm receiving and accepting monthly rent payments from GMX.
So it had at least, perhaps, I'm sorry.
Let me just have a quick point of clarification. My review of the record says that Tenbar was not given information about the transfer of assets from AMG to GMX.
I don't necessarily agree with that. If I understand your question correctly, there were assets in the AGM agreement that were valued at $243,000 that were part of that agreement. I agree there's no evidence that in the record that the sale agreement was actually delivered to Mr. Barber. I don't see any evidence either that he accepted it. He seemed to rely upon, in starting that waiver argument, the communication that he received from Mr. Farekis as to who the tenant was, because after all, what is he concerned about? He's concerned about, I'm the landlord, I want to get paid, this is who's going to pay me, I want to do the payments, receive them, and I want to perform my part, for example, when I'm asked to perform maintenance and services.
So going back to that point where at least there's an awareness with Tenbar, Mr. Barber, that something has changed. And I have somebody else who's operating here in my premises, that if they wanted to assert a assignment issue, that they had to act at that point, and the waiver may have started to occur at that point, and that's a fact issue for the jury. Did they, along the way, waive? Did they waive once they became very clear and they were told, talk to your tenant, and the tenant is in Apache for 5 or 6 months? Did they waive at that point? Is that a fact issue?
It is. That's where it started, I think, and the court can determine, the jury, can determine that.
Can we determine it as a matter of law?
No, you cannot, because there's questions of fact about when the waiver started, what was the waiver. We also have, as pointed out in their briefing in particular, that there is a part of the original lease that talks about fill these forms out if there's going to be a transfer. Well, Mr. Barber elected never to, bring that up. I know he's an elderly gentleman, that's not an excuse, but he decided it's not necessary for me to go have, when I learned of this change of tenant, to have them fill out that particular form.
Was the onus on Tenbar or was the onus on the lessee who was receiving the assignment?
Well, the onus is on the landlord because he's want to ensure that he's got a lease to stand up to collect the rent.
In fact, there's some case law in Arizona that suggests the landlord ends up facing a presumption under these circumstances.
Well, that also answers that question. With that, I would like to reserve the remaining time. Thank you very much.
I'm going to apologize now as I constantly clear my throat this morning. Good morning. May it please the court. Daniel Peabody from Quarles and Brady on behalf of appellees Tenbar Incorporated and William Barber. This is really a simple case. This is a case about plaintiffs seeking a windfall of speculative damages for their own mistakes and seeking it against the wrong party. This appeal...
Well, I'm the wrong party, because let's just sit here and say we agree that certainly the FHA for ACUS and some of the other people may be appropriate parties, may have claims against them. But your client is the landlord on the lease, right?
Correct.
And your client sent the eviction letter, right?
Which eviction letter are you discussing?
Sent a letter that was drafted by someone from FHA saying you breached the lease, you didn't pay your rent in January, I'm terminating the lease, and we're making FHA the tenant under a new lease. That went out from your client.
My client signed that letter.
That's your client.
Bill Barber, yes, Your Honor. That's
Okay,
correct.
so your client did that, and that was wrong by your own client's testimony. Rent had been paid.
The issue, however, Your Honor, is that there's two things. First, the first part of that letter, you're talking about the January 2018 letter, discusses the assignment of the lease and him never having approved the assignment of the
So
lease.
he's asserting I didn't do it. I understand. But then we've also got the other pieces. So this is his letter. I don't care who wrote it. He signed it. He took ownership, right?
We'll concede that, Your Honor, yes.
I think you have to. I think
Yes.
it's kind of hard to say under the facts
Correct.
that he didn't.
You-
So isn't it a waiver question? How does that
No, Your
answer
Honor,
a
and
question
here's-
of waiver?
No, Your Honor, here's why. First, waiver was never argued below. That's the first issue. The other side has never once addressed waiver, has never addressed Mr. Barber having waived the assignment of lease provision. That's the first thing. The second thing, Your Honor, is that the January 2018 letter is inconsequential, and here's why. This gets to the first issue regarding damages and the second issue of causation. And to Judge Foster's point earlier, the lease issue or the tenancy issue is not determinative. This court can affirm without having to address that at all, and that's because the damages and causation issue take care of all of the claims. Now, with respect to the January 2018 letter, Your Honor, the January 2018 letter was, we'll concede, signed by Mr. Barber, sent to FWA. GMX never received that letter. Reply brief, page 6, they concede that they never received that letter. So that letter never went to GMX. Then, February 20th, 2018, GMX sends a termination letter to FWA. The termination letter is what really sets off the chain of events for the alleged damages. The February 20th, 2018 letter terminates the management agreement. The management agreement is what severs ties between GMX and the facility. Okay, it severs the rights to use the DRC and the ATO. Now, it's not disputed that the DRC and the ATO are absolutely necessary for anybody to cultivate medical marijuana. It's also not conceded that GMX did not have a DRC, did not have an ATO. Their only connection was to the DRC and ATO that FWA had. They only had that connection through the management agreement. That's why GMX wants to downplay the management agreement, because it is the linchpin here to all of the alleged damages. When they send the termination letter, GMX, the testimony from FWA is that they felt compelled at that point to terminate, to revoke the DA cards. Once the DA cards were revoked, GMX could not access the facility. That is why FWA had armed guards remove and restrict access from GMX employees to the facility. At that point, Your Honor, that's when the alleged damages take effect.
Don't we have a fact question there as to what they were acting on, including whether they were acting on a letter that your client sent saying, I'm making you the tenant? I mean, that's part of the facts that are in this, and you're asking us to just pretend that that's not there. All these other things also happened, but they were acting based on your client's letter as the tenant.
No, Your Honor, and here's why. Because the termination letter, it wasn't FWA that terminated the management agreement. It was GMX, and GMX terminated the management agreement without having received the January 2018 letter. Therefore, the January 2018 letter is entirely inconsequential to this analysis, Your Honor.
Okay.
Once the termination of the management agreement occurs, GMX is compelled, FWA is compelled, according to the testimony of Mr. Farakis, to revoke those DA cards. That's it. After he revokes the DA cards, they can't access the facility. That's the law. That's what all of their alleged damages stem from. And, Your Honor, on damages, that's my first point as to why this court can affirm the decision of the Superior Court. The issue of damages has been waived. The Superior Court found or ruled that the damages from GMX were entirely speculative. There is nothing at all in the opening brief addressing that issue. There is nothing from which this court could base a decision to overturn that ruling in the opening brief. It doesn't exist. The term speculation, the term conjecture, none of that comes up in the opening brief. That argument is therefore waived. But even if this court did not want to, or was not inclined to find that a waiver existed as to that argument, the damages are just entirely speculative. Even if they could get into the facility, even if they could, or even if they were tenants, once they don't have DA cards, they can't go into the facility. And that was a decision that, it's undisputed, was entirely up to the sole discretion of the DRC holder. FWA had sole discretion as to who could enter the facility through a DA card. That's undisputed. So they don't have access to a DA card. They don't have ties to any DRC or ATO. They fall back on this non-binding, non-exclusive letter of intent with BHI, but again, that's non-binding and it's non-exclusive. And
So we're to ignore the fact that your client terminated a lease, never left them go back in and get the property, that's undisputed, was left there. It's there, regardless of how the lockout happened. Your client terminated, said, you're done. They acted as, FHA acted as the tenant, did a lot of different things, may have other reasons to do it too, but then your client, at the moment that you sent that termination letter, took possession of that property. It was in your client's hands, and then your client later leased it to FHA, allowing property that wasn't FHA's, that was Apache's, that at that point under the agreement belonged to GMX, and your client left it all go over. So even, let's not, the property, the value of whether they could have made money or not, there's personal property there that your client held and turned over to a third party under a new lease.
Your Honor, my client himself could not even access that property. But
your client held it. I don't care about access at that point. Your client had it. And your client had a duty at that point to deal with third-party property. Isn't that the law? Your client is the landlord who terminated a lease, and there's third-party property in that facility.
Your Honor, my client did not possess that property. That property is in the facility that my client cannot access, even if he wanted to, Your Honor.
Access isn't the point. That's like saying I don't have the key. There may be a reason your client physically can't walk in, but your client can't give away third-party property.
My client didn't give away third-party property, Your Honor. The dispute at that point, if GMX was the legal tenant, once that DA card is revoked, they can't access the facility. At that point, Your Honor, there's a dispute between somebody who's holding the property, conversion or trespass, and
there's also a dispute against the landlord when the landlord has that property in its possession. which your client did the moment your client terminated the lease.
Your Honor,
Your client terminated the lease. I don't want to go off track, right?
I disagree with that, Your Honor.
I'm sorry, the letter says I'm terminating the lease immediately.
Your Honor, the testimony from my client was that there was
That's
never
not,
any...
I'm talking about the letter, so then you want to create a fact issue, we can do that too. The letter says that, and either they did or they didn't terminate. If you take the position they didn't, I don't know how we don't have a fact issue. Tell me how.
Your Honor, the termination letter that you're talking of, Your Honor, so I guess what you're talking about is the damages with respect to personal property then? Is that what we're...
I don't think I've been too vague on that, but I want to come back to my question. Is it your position your client didn't terminate the lease?
Your Honor,
Yes or no?
the lease was not terminated, Your Honor.
So whether that letter is effective is a fact issue at this point.
No, Your Honor, I disagree.
How is it not?
Your Honor, because the court doesn't have to get there. Again, there's no damages here, and there's no causation here. The other side cannot show that, they can't show any damages. Again, that issue's been waived, and they can't show, all of their damages
So I want to
are...
set the damages issue aside. If we find that there can be damages under this. What I'm taking here is you're saying there's a fact issue as to whether the lease in fact was terminated.
No, I don't think that there is a dispute in that.
Your
issue.
client sent a termination letter, but your client's saying they didn't terminate. That's what you've just said.
Your Honor, my client signed that letter. That's what we've discussed.
Your client signed a letter from Tenbar saying, I'm terminating the lease, and your client was the person with authority at Tenbar to do so.
Your Honor, I don't think at that point anybody thought that the lease was terminated.
Okay, so it's a fact issue.
They're still in the property. AGM is still, GMX is still the management company that's working in the property. Everybody's still working under the assumption that the lease is still going.
So your client sent that letter and didn't even think it was terminated?
Your Honor,
That's what you want us to find as a matter of law?
Your Honor, my client didn't send that letter. That's the issue here. The GMX never received that letter.
Your client sent it to FHA saying, I'm making you the new person. Your client sent a letter terminating a lease, and you're saying we're supposed to ignore the fact that that happened. Your client sent it to the one they chose to send it to.
What I'm saying is that January 2018 letter, at the end of the day, does not matter, and that's because GMX never received it. That's not disputed. GMX simply never received it. Moreover, the actions of FWA were not affected by that letter. So
You want us to conclude that, but how do we look at a record where we've got a letter like that and the other actions and say that this had absolutely no impact?
Your Honor, because there was no action after FWA had that letter. There was nothing taken. The only thing that happened after that was the termination of
Which is what a jury can say, well, we infer that there was nothing, or we infer when you take that letter and you take the thing that GMX sent, FHLA felt empowered to, but that's what inferences are. You're asking us to infer that because no action was taken immediately, that the second action is independent.
No, Your Honor, there is no evidence. There is no evidence that that letter had any bearing at all. There isn't. There's nothing in the record. There's no testimony from Mr. Farakis. GMX is conceding that they never received that letter. So that letter there's simply no evidence to say that that letter did anything at all.
But isn't that what inferences are about? That you get to say, look, this is true, and this is true. Now, what do we infer from that? I don't have to necessarily have a ton of evidence because that's what inferences are about. I had 3 different things happen, and now is it reasonable to infer from that it could have played a role? Your client gets to argue to a jury, no, it didn't do anything, do the exact same thing you're arguing to me, but they get to say, wait, that doesn't make sense. Common sense says when this happened, they all played a role. Isn't that what a jury argument is?
No, Your Honor, and that's because there's no reasonable juror that could make this conclusion. GMX didn't receive the letter. Without having received that letter, they themselves send this letter terminating the management agreement. The testimony from Mike Farakis is that once he received that letter, and Your Honor, it's important to note the timing of that letter. He received that letter on a Friday afternoon. The testimony is that the very following Monday, the DA cards were revoked. He had no choice. If that letter had some type of bearing, he wouldn't need to wait until after receiving the termination letter that he had no idea was coming.
But what he did have when he got the termination letter is also your client's letter. So you had two things
Your Honor,
that may have resulted in that quick action.
Your Honor, what he had was the DA cards, or the DRC, and that had to be protected. And that much is clear. There's no dispute about that. The DRC and the ATO had to be protected. And now you have a management company who has severed ties with you and is saying, I'm no longer bound.
When did your client terminate the lease? I'm sorry.
Let me ask a quick question before I forget. All right, so you said the timing is important. They received the letter terminating the management contract on a Friday, and you said on Monday the cards were revoked.
That's correct, Your Honor.
Revoked by whom?
I'm not precisely sure how that process works, but the actions were taken immediately to revoke it by FWA, the holder of the DRC and the ATO.
Okay, so why is the timing critical if they're the ones that received the letter and locked them out basically the next day? Doesn't that kind of go against what you're saying here?
No, Your Honor. They received the management, or the termination of the management agreement.
Correct.
Not the
And
termination
in
of the lease.
Response, they terminate all of the cards and access to the property. Did the following day?
That's
business
correct,
day.
Your Honor.
Okay.
Yes.
And it's your client or Farrakis that did that?
Farrakis. It was
Not
the FWA.
the department that did it?
Tenbar, and I assume that there has to be some steps taken with ADHS to revoke the DA cards, but there's no dispute that the sole discretion with respect to the DA cards lies with the DRC holder.
Okay.
And that's because
I just-
under the statute, the DA cards can only come from the dispensary holder.
Okay, I've just never heard of the government working that quickly.
It
I
just-
wanted to make sure.
It
Thank you.
wasn't. No, I don't
Okay.
disagree with
No.
anything he said. Can I ask you though, just to follow up, I do want to I don't want to dominate too much, but because coming back to, when did your client terminate the lease?
Your Honor, the AGM lease was in place, I believe, from 2013 going forward. To your point earlier, Your Honor.
Well, when did
there
they
was-
terminate that?
I'm going to get there. But there was no...
I'd like just to answer that question, then give your explanation. When did they terminate?
The AGM lease, Your Honor, was not terminated. The AGM lease would have been terminated post February 2018.
So was it terminated? You just said it was not terminated.
After February 2018, Your Honor, I'm sure it was, but it would have been after the relevant events, Your Honor. But to Your Honor's point earlier, the only communication that Mr. Barber and Tenbar received with respect to AGM was the October 2015 letter from Farrakis saying, we have set up GMX as a management company. That's what he was aware of. And specifically, he was told GMX would be paying the rent. That's why this argument with respect to the rent, it doesn't do anything, Your Honor. It's perfectly normal, I think, to Judge Campbell's point earlier, for a management company to be paying rent. Mr. Barber had noticed that they would be paying rent. They were acting as a management company. That's certainly not uncommon in this industry in particular, in most industries. So he's receiving the rent checks from GMX, doesn't have any bearing at all.
And no bearing after the August-September communication that we need this.
No, Your Honor.
To show that we're the tenant.
Yeah, and
Your client gave him that document to give to a third-party government regulatory agency to hold themselves as a tenant.
Your
No
Honor,
relevance.
First and foremost, there's no testimony from the City of Phoenix or anybody with respect to what was actually asked of GMX. The only thing we have is that they were asking with help dealing with the City of Phoenix. Now, what's important, Your Honor, is the testimony.
I get that. I know that's not there, but I'm talking about what your client did. Your client's understanding was they had to deal with the City of Phoenix, and they had to show they were the tenant.
That's incorrect, Your Honor.
Then why did your client even scratch out the tenant's name?
Their name was not on the lease.
Right.
They needed assistance with dealing with the City of Phoenix, so Mr. Barber did what he could do to assist them with that.
He put their name on that
Your Honor,
lease.
but what's important, though, is...
No, but
the
he scratched it out and he wrote their name.
Correct, Your Honor.
And he knew they were going to take that to the City of Phoenix and show they were the tenant.
I don't think
And or
that's
are you
clear.
saying that we should consider that a fact issue as to whether he
No, Your
understood
Honor,
it.
I don't think there is a dispute about fact here, and that's because if we look at Bruce Camden's testimony, Your Honor, and this is something that is glaringly left out of the opening brief and the reply brief, Your Honor, the testimony from Bruce Camden is when I called Bill Barber to discuss this, he didn't want to discuss with me, the future steps. This is the words from Bruce Camden, the future steps to get to a lease that would reflect GMX as the legal tenant. So, Your Honor, at that point in time, there is a recognition that that GMX was not the legal tenant. There would be future steps that would need to be taken. They can't overcome that, Your Honor. There is no dispute that at that moment, GMX was aware they were not the legal tenant, and there would be future steps that would need to be taken, future steps that never occurred. So, Your Honor, what we have here is we have absolutely no damages because they're speculative. We have no causation because the DRC, the ATO were entirely within the discretion of FWA, and once those were cut off, that is what led to the alleged damages, not any action of Tenbar. And then, Your Honor, we have the fact that at that moment, if the court needs to get there, if it can overcome the hurdle of damages, causation, and the complete waiver of the damages argument, if the court can get to the issue of tenancy, then you have to somehow address the fact that Bruce Camden on that day said, I recognize that something future would have to happen to make us the legal tenant. At that point, he recognized this scratched out lease did not make us the legal tenant. Something future would need to happen. And, Your Honor, that's something that they can't overcome. And so for that reason, I recognize that I'm out of time. Your Honor, I would respectfully request that this court affirm the decision of the Superior Court in granting summary judgment in favor of Tenbar. Thank you.
Thank you, counsel. When you're ready.
I have a few issues to address and clean up. First, we are the plaintiff in the underlying case. We wouldn't raise waiver as a defense because we are the plaintiff, but they did raise it. We checked the record. It's at record 17, which is defendant's answer. So they are the ones that put into issue the defense of waiver. Second, they still seem to claim that we abandoned and didn't discuss damages, but in page 17 of our brief, opening brief, there's extensive quote about listing all the damages. And they're not speculative. Rent is a hard number. The ability to perform the management agreement we were bound to do is taken away because we can't get in the premises to do our work. The DRC thing, that's really a red herring because even though we may have no access under the DRC laws to the premises, we're still the tenant. We're still the lessee. So we still have the obligation to pay rent. And there's evidence in the record of how we went from CSI, who was a DRC ATO holder, and transitioned into the ESG, FWA. And there's also evidence in the record what the procedures are when there's going to be a change there. And they already did a change. They're just going to follow those procedures again, as Mr. Camden testified. All you need to do is just notify the DRC. They have the owner, which would be FWA, has a time to come pick up their plants or whatever condition they're in, and they take all that out. And we still have an empty building, so to speak, full of equipment that's used to grow this kind of crop. And so the DRC is not an issue worthy of consideration here. We didn't really have a need to go back in the facility at all because we couldn't perform our management duties under the agreement. The next point I'd like to talk about is the lease termination. There's a lot of questions you asked about the lease termination here. I'd like to point out that the written lease was originally, in this case, with AMG. Of course, we've already talked about how that was transferred, but then remember, AMG went out of business. And so they, unlike what Judge Martin mentioned, they couldn't be part of a lease any longer. The significance of that that January letter is also one other thing that has not been mentioned yet. That letter that FWA and its representatives brought to Mr. Barber, prepared for Mr. Barber, asked him to sign, that he did sign. The importance of that is that gave, in the mind of Forakus anyway, authority to go take over the premises and pull the security guards in and take over the premises. because Barber's signature authorized Mr. Farekis, and there's no evidence there was anything else, to go take that kind of action. So with that, I have nothing further to address.
Just curiosity more than anything. In the 2017 matter, Judge Martin ordered GMX to be allowed to retrieve their property from that location. Did that ever occur?
Yeah, the evidence you have in your record is that there was a walkthrough done between a JMX representative and an FWA representative. The GMX representative was unable to take the safe and get the cash out of the safe. In particular, the premises in the record were also reviewed to demonstrate what the equipment and the property was, that of course you can't just take it out at that moment's notice. And so it remained on the premises.
Thank you, counsel.
I have one question, if it's okay,
Yes, please.
which is, let's say we accept that there was not enough evidence to support an assignment, breach of contract claim gone. What happens under the unjust enrichment claim at that point?
Well, we go to the promissory estoppel claim because there's detrimental reliance clearly demonstrated in the
I want you
record.
to focus on really the unjust enrichment.
Oh, yeah, absolutely. Our brief in the record demonstrates the elements of unjust enrichment, the impoverishment, and the enrichment. You know, the enrichment, of course, is that Mr. Barber received rent. He received the equipment as the owner of the land that remained on the premises. The impoverishment was that we were unable to perform our duties under the management agreement because of interference with our lease at the behest of Farekis after he got approval from Mr. Barber.
Okay, thank you.
Any questions?
No, I don't think so.
All right. Anything further, counsel?
No, thank you very much.
Definitely interesting case. We will take this matter under advisement. We will issue a written ruling in due course. At this point, we are adjourned.